The Good Conduct Time Allowance credits, or GCTA, became controversial a few years back when the public objected to the grant of more time credits to persons deprived of liberty, which would have led to the early release of some PDLs serving time for committing heinous crimes. The implementing rules and regulations were subsequently changed, but the IRR itself was challenged before the Supreme Court. Should PDLs convicted of heinous crimes benefit from more generous GCTA credits? Hi, I'm Atty. Mike Navalio, Supreme Court Chief Communications Officer. It's the 20th of December 2024, and today we talk about the case of Narciso B. Ginto et al. Versus Department of Justice et al., decided on April 3, 2024. It's an unbanked decision penned by Supreme Court Associate Justice Maria Filomena D. Singh. And joining us to talk about this case is Attorney Dimaano from the Office of Associate Justice Singh. Hi, Attorney Jelsi. Thanks for joining us and welcome to the Supreme Court Podcast.
Good day, Attorney Mike, and to all the listeners of the podcast.
All right, so Attorney Jelsi, let's talk about the factual antecedents that led to this case. First, what is Good Conduct Time Allowance and why did it become an issue prior to the filing of this current petition?
Okay, to start, Good Conduct Time Allowance, as defined under the law, pertains to the privilege granted to an offender which entitles him to a reduction of his or her jail or prison term as a reward for good conduct and exemplary behavior. This takes into account the offender's active involvement in rehabilitation programs, productive participation in authorized work activities or accomplishment of exemplary deeds, and faithful obedience to all prison rules and regulations. And the relevant law in this case is Republic Act Number 10592, which was signed into law in 2013 and amended Articles 29, 94, 97, 98, and 99 of the Revised Penal Code, or the RPC. Thereafter, the first implementing rules and regulations, or the IRR of the law, was issued in 2014, and this 2014 IRR provided for the prospective applicability of RA-10592, but this provision was subsequently invalidated in the case of inmates of the New Bilibid Prison versus Dilima, decided in June 2019, where the Supreme Court ruled that the GCTA law can be applied retroactively following the doctrine in criminal law that penal laws favorable to the accused should be applied retroactively.
So, Attorney Jelsi, just to unpack some of the things that you mentioned. So this law, RA-10592, actually gave more time credits to qualified persons deprived of liberty, right? So the change was that in the first IRR, it was only applied prospectively. But the Supreme Court said, no, you have to also apply it prospectively. Explain to us this concept, this criminal law concept, that if there is provision in the law that is favorable to the accused, then it must also be applied retroactively. Can you elaborate on this?
Yes, because in this case, since the new law, the Republic Act Number 10592, expanded the scope of the application of GCTA law to include those under preventive imprisonment. These are favorable and advantageous to the accused. So under the doctrine in criminal law, it should be applied retroactively. So the provision of providing for prospective applicability was struck down by the Supreme Court in the Dilima case.
And for the benefit of our listeners, this will only apply if it's beneficial to the accused.
Yes.
If it's prejudicial,
yes,
then it won't have any retroactive.
Yes.
Right? So how did the 2019 IRR differ from the provision of RA-10592, amending Article 97 of the Revised Penal Code?
As mentioned earlier, the 2019 IRR absolutely disqualified persons convicted of heinous crimes from earning GCTA credits.
All right. So how did the Supreme Court resolve this issue?
So the Supreme Court ruled that the DOJ, in issuing the 2019 IRR, exceeded its power of subordinate legislation when it excluded persons convicted of heinous crimes from the benefits of the GCTA law, since Article 97, as amended, did not contain any qualification as to the applicability of the GCTA law with respect to convicted prisoners. Article 97, as amended, used the conjunction or to separate the two categories entitled to GCTA. Otherwise stated, the law is clear either number one, any offender qualified for credit for preventive imprisonment under Article 29 of the RPC as amended, or two, any convicted prisoner in any penal institution, rehabilitation, or detention center, or in any other local jail made avail of the benefits granted by RA-10592.
So, just to be clear to our listeners, who then are entitled to earn good conduct time allowance credits? I think this case sums up and clarifies who are qualified and who are not qualified.
Yes, we have to distinguish. During preventive imprisonment, all offenders who are not recidivists, habitual delinquents, escapees, and charged with heinous crimes are entitled to earn GCTA credits. On the other hand, if a prisoner is already convicted, any convicted prisoner may earn GCTA credits regardless if they are recidivists, habitual delinquents, escapees, or convicted of heinous crimes, so long as they are in any penal institution, rehabilitation, or detention center, or any local jail.
And we've been hearing these words, recidivist, habitual delinquents. Can we define for our audience what does a recidivist mean and who are habitual delinquents?
Yes. These are terms that are familiar with the law students and lawyers who are listening to the podcast. So, recidivists, under the law, are defined as persons who, at the time of their trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of the RPC. On the other hand, habitual delinquents are persons who, within a period of 10 years from the date of release from prison or last conviction of the crimes of serious or less serious physical injuries, robbery, theft, estafa, and falsification, is found guilty of any of the said crimes a third time or oftener.
All right, that should be clear. Now, just to close our discussion, Attorney Chelsea, what's our main takeaway from this case?
So, to reiterate, the main takeaway is that any convicted prisoner, regardless of the crime committed, even if it is a heinous crime, is entitled to the benefits of the GCTA law, so long as they are in any penal institution, rehabilitation, or detention center, or any local jail. This carries out the philosophy behind our correctional system, which seeks the reformation of prisoners and allows them another opportunity to become contributing members of the society.
All right. So, thank you so much, Attorney Chelsea, for joining us today.
Thank you, Attorney Mike.